All right, welcome back, everyone. We have packed a lot into this day, which is very exciting, but also quite exhausting, so thank you for sticking in there with us on a Friday afternoon. We happen to have the panel right after lunch, and we have lots and lots of data to share with you, so this should be great, but our panelists will make it extremely exciting. So our panel is what works in child access mediation and why. And we have three very experienced presenters on this topic. So at the other table, we have our first presenter will be Toby Treem Guerin, who's a graduate of this law school and managing director for the Center for Dispute Resolution here at Maryland Carey Law, as well as a clinical instructor in the mediation clinic. As most of you in the room know, Toby has 15 years of experience mediating and facilitating in a variety of venues, including government agencies, communities, nonprofit organizations, schools, and court systems. She has trained hundreds of mediators on a variety of topics and has been involved in research about court-connected dispute resolution programs, including the ADR landscape, which was produced as part of a comprehensive statewide research study conducted by a consortium of researchers for the Maryland judiciary. So Toby will be starting our panel with an overview of the very rich landscape that we have here in the state of Maryland in various court ADR programs, mediation, as well as other dispute resolution processes. Today, of course, given our panel, she's going to be focusing on child custody in particular. So after Toby's presentation of the general landscape, we'll get an insider's view of what works in court-annexed family ADR programs from Wendy Sawyer. Wendy is an attorney, also a graduate of this law school, and has been director of the Office of Family Mediation for the Circuit Court for Baltimore County for 12 years and was an on-staff mediator for 8 years before that. She's developed some pretty innovative mediation programs in child dependency, contempt cases, including financial issues for pro se litigants, adult guardianship, and a unique program designed for resolving child access issues in high conflict family cases. And in addition to her leadership roles in ADR programs, she's provided lots of mediation training for mediators, and she's going to share her observation about what works in custody and family mediation from that perspective of being an experienced court program director. And our final presenter, Dr. Lorg Trokoudian, is going to ground our discussion in some groundbreaking research that most of you in the room are familiar with, for which she was the principal investigator about the costs and benefits of court-based dispute resolution. And the piece of the research she'll be talking about today is the first, really, that we know of that applied rigorous scientific behavioral observation methodology combined with regression analysis to actual mediation observation studies, mediation observation in the moment, right, by the researchers, which she describes the methodology so much better than I do. She'll spend some time telling you about that methodology. And what the impact of specific mediator interventions are on party attitudes and case outcomes. So it's very exciting research. In addition to being the executive director of Community Mediation Maryland, Lorg has a PhD in economics from Johns Hopkins University and a record of other groundbreaking empirical research about mediation. I should say that another thing about Lorg you should know is that this weekend, it's starting tomorrow? Tomorrow morning. She has community mediation, as many of you know, does prisoner reentry mediation. And to raise awareness of that service and also to raise funds for that service, Lorg is running from Hagerstown, where the prisons are, to Baltimore City. So we wish her luck in that endeavor. And if you'd like to wish her more than luck, you can go to the marylandmediation.org website and actually donate. She didn't ask me to do that plug, but I think it's an endeavor that we all definitely should support.
Or you can run with me.
I personally would prefer to give you some money, but we'll go from there. So Laura's going to describe the study as it applied in the child custody cases. It's getting a lot of national and international attention, and I think is a real example of rigorous second-generation ADR research that's very exciting and that I hope will lead to more research of its kind. So let me first turn it over to Toby Guerin to get us started with the landscape.
All right, let's pull this up for you. Okay, so just to give you all a little bit of context, Laura's going to talk a little bit more about that, but I guess it is about 4 years ago, the Maryland judiciary says, wow, we're doing a lot of work in the field of dispute resolution, putting a lot of resources into this. Let's maybe take a look a little bit at what we're doing and how it's working. And so that's kind of generally how the research came about. It is a highly resource intensive, very rigorous research, and so as a result, we were not able to take the deep dive, as some say, into the about 80 different dispute resolution programs in Maryland that are affiliated with courts. And so to complement the empirical research, what was accompanying that is what we are calling the ADR landscape, which is an overview of the landscape of dispute resolution in Maryland. And for today, I'm going to focus on the family context. So for the landscape, what we did is that we only looked at court-affiliated dispute resolution programs. So to the extent that a court partnered with a community mediation center or other provider, then we got the information from the court about that, but we did not go and look at all the community providers. So just to kind of create that line. We looked at any ADR process because what we said is what you say you're doing and what you're actually doing may be two different things. So we're not going to get into the weeds about what it is or isn't. We're just going to say, what do you call it? And then what are your requirements for each? And so we ended up looking at mediation, facilitation, settlement conferencing, and community conferencing are tend to be the things that the court works with. These were one-on-one, in-person, majority interviews with the person responsible for managing the program, right? So the person who could actually answer the day-to-day information about the program, and that was different in each jurisdiction. And then this is descriptive programmatic information, right? So we are not doing any sort of judgment or testing the veracity of the information that was provided. We kind of trusted in the person who gave us the information, knew the information that was being provided, and are literally just presenting it back in a more organized format. So just to give the overall landscape of Maryland, right? So Maryland has 24 unique jurisdictions, if you include Baltimore City. The Court of Special Appeals has a dispute resolution program, and then in the circuit court, there are 14 general civil programs. In Maryland, child access mediation is required, so it exists in all 24 of the jurisdictions. 20 use child welfare, which is child in need of assistance and termination of parental rights. 18 of those jurisdictions also offer some type of marital property dispute resolution. And at the time, which I should kind of say, this information was largely gathered, I would say about 2012 would be kind of the year that most of this information is representing. There were 8 programs that handled juvenile matters, and at the time it was planned to expand until 10. In our orphans court, which is the probate court here in Maryland, there are 2 jurisdictions that have programs, and then at the district court, which is the lowest level, kind of called the small claims court in other places, there were, for civil cases, 15 days of trial, 13 jurisdictions that also offered pre-trial, and 12 that offered dispute resolution for some type of criminal matter. Okay, so that's just the overall, so you get the kind of breadth of the landscape. I'm going to focus on domestic dispute resolution. So for those of you that don't know Maryland, this is the map of Maryland. And our jurisdiction. So to the extent that you can see the colors on here, of course, all of our jurisdictions offer some type of child access mediation. And then you can see which ones also offer marital property mediation, and then settlement conferencing for family matters. All right. So there's a lot of stars on our state, which we're very proud of. But one of the things that I think really came out as we were looking at the landscape is that really, particularly when it comes to the circuit court level as a decentralized court system here in Maryland, no two programs really are the same. And that has many advantages and also disadvantages, right? So an individual who's going through a process in one jurisdiction may go through a very different process in another jurisdiction. And so what does that mean? And so first we wanted to gather kind of the information. And so the areas that I'm going to touch on briefly today are these four up here. Okay, so these are the Maryland court rules, Title 17, of what mediators that are doing mediation in the family context need to meet, all of these requirements. Okay. And then in addition, some courts have their mediators need to meet additional requirements. 12 of those programs do. In 3 of them, the neutral also has to be an attorney. And 2, they have to be able to say that they have an office in the county. In 5, they actually have to explicitly agree to provide pro bono dispute resolution services. 6 of them require mediators to be members of the Maryland Program for Mediator Excellence, which is a mediator quality assistance program here in Maryland. 1 at the time, I believe this has since changed, required their mediators to meet a performance-based certification, and 3 of them required the mediators, or the neutrals, I should say, to have some type of liability insurance. Okay. And then these are the other courses. I'm going to focus mostly on mediation, but other ADR processes that are offered is settlement conferencing, largely, which is provided by an active or retired judge, and facilitation, which tends to be, from what I gathered from my interviews, kind of the day of service that was provided, often for cases that maybe had resolved some of the issues, but there was one kind of issue that still needed to be resolved, and these were largely conducted by attorneys who are doing that day of. All right. So the referral process really varied, right? When does the referral to dispute resolution occur, right? Sometimes it occurred at the scheduling conference, sometimes the day of trial, and in some jurisdictions you won't even get a trial date until you actually have engaged in the process. Right. Also varied on who is determining whether this referral is happening. In some cases, it's the program administrator. Almost any place, if the party requests it, they will honor that request. And in some instances, it does require the judge to make that referral to dispute resolution. And then where they're occurring. Ashman at the courthouse, the mediator's office, or one of the attorney's offices. And so this information, as Lorig starts to talk a little bit more about what we're finding, is why it's so important to kind of know the landscape, because then it allows programs that maybe weren't part of the in-depth research be able to look at what they do and what was found. Okay, so programs also used a variety of quality control and evaluation measures with regard to the qualifications of the neutrals, what they were required with regard to continuing ed, how they might be removed from the roster, how they looked at what participants thought, and then, the feedback and information they got from the mediators. And just as a side, this is particularly important in family matters because the way the court works is you are required, basically, to participate in mediation if you have a child and you're going through the court system. And so kind of what is actually being provided is even kind of more important to look at, right? So some of the continuing education that the court rules requires 4 hours of mediation-related education per year, and those programs that required mediators to be part of the Maryland Program for Mediator Excellence have an additional annual requirement for that. Right. If you're on a roster, the court rules say that you can be removed if you don't meet the requirements or for other good cause following notice. Most of the programs, remember there are 24, only 3 have a formal process, but most commented on informal ways that they use, which generally just involves not referring cases to that neutral anymore. All right. And then, so how do we gather information? How are they evaluating the programs? So out of the 24 programs, 15 use some type of participant evaluation, and 10 require some type of report from the mediator. 8 of those use both, and 7 use neither. Right? And that drops significantly when you look at settlement conferencing as the method of dispute resolution that's being provided. And this I wanted to focus on a little bit more in my time left, right? So because the court requires people to participate in this process, it does arguably have an obligation to allow people to have access to the process. And so these are the main ways that that is provided by these variety of programs. So one category is what I called court-subsidized dispute resolution, where the dispute resolution services are provided by salaried neutrals, or they're the payment of a court-approved dispute resolution provider, right? So this is where the court is paying the person who is providing the service, right? There's pro bono dispute resolution, which technically, according to any mediator that is accepted onto the court roster, is required to provide. And so these are neutrals who are providing the service at no cost that would otherwise receive payment for those services. And then there are non-fee-for-service providers, where the dispute resolution services are provided at no charge to the parties by a court-approved dispute resolution organization. And so in this case, that often involves community mediation or a law school clinic. So this is how it breaks down, at least at the time of the programs provided throughout the state. 6 of the programs have some type of staff neutrals or contract mediator that's provided by the court. Right. Some will use recalled or retired judges for the settlement conferences, in which case the court is paying for those services. Right. Although pro bono dispute resolution is required for anyone who is on a court roster, only 5 counties indicated that they actually used this as a way to provide dispute resolution services. Right. In the field of domestic mediation, about half of the jurisdictions, 50%, not about 50%, are using community mediation centers. And as you heard from Jane Murphy, University of Baltimore has a mediation clinic, right? So there are fee waivers that the court has provided with budget cuts. This is one of the areas which has been impacted. And so that really has pushed some centers to be more creative, either using more pro bono services, exploring partnerships with community mediation, or reallocating funds in some way. All right. So I just wanted to create that general overview as you hear more from Wendy, who has one of the programs in this study, and then the overall kind of research to really help kind of provide a backdrop to that. The research that Laura's going to talk about, as well as the entire ADR landscape, is available at this website, and as more and more reports become finalized, they will continue to be put up on the website.